To order and introduce the board members. I'm Daryl Hawkins, chairman of the board, and we also have here Kent Glenzer and Stephen Milich, and they're not on my screen. Let me push a button. There we go. And glad to have you all here and join us. Alicia, are there any calls in for public comment?
At this time, I don't see anyone with their hand raised.
Okay.
Okay. So that was general public comment for items not on the agenda.
Okay.
Correct.
Good. Thank you. The agenda is just one item: to adopt written decision following the hearing on violations of California Subcontract and Subcontractors Fair Practices Act, Public Contract Code, Section 4100, and during construction of the Monterey Conference Center, renovations by Stronghold Engineering Incorporated, the prime contractor on the project. Any comments or questions by anyone?
Well, I'll just say, as the staff member responsible here, I tried to distill the board's deliberations from the November 18th, 2020 hearing and the findings they made, and then the ultimate vote imposing penalties for 2 violations. So I tried to capture all that in the written decision, but of course you are welcome to edit and provide further direction as you see fit.
Okay, good. And as we always announce, this is an informal hearing. Informal rules of evidence do not apply, and we may consider any evidence or information deemed relevant or reasonably reliable. And so I think really the next step, I'm sure the board members have read the 6-page summary. And Stephen, you have something to discuss.
If it's in order, Mr. Chair, I would move that we approve the findings and that you sign.
Sorry, before we go to formal motion, let's, I just want to make sure we take public comment if there is any on this specific item.
We actually have we do have one person with their hand raised. So let me go ahead and get that going. Okay, Mr. Van Orm, go ahead. You're ready for public comments if you're ready.
Thank you. Can you hear me?
We can. Go ahead.
Okay. I'd like to comment on one primary thing right now, and that this is a new written submission where, again, this was made by the city attorneys as part of their claims against Stronghold, and there are new findings in here that I'd like to address briefly that I don't believe were considered by the board in the last discussions. But before I do that, I want to talk about generally the process that got us here. And I guess this ties into one of the first findings, which is that there was, that this board is acting, and this is on page 6 of the packet, that the board is operating under jurisdiction over this matter under Monterey City Code 2-801D. And this gets back to a general issue that I felt like this process has suffered from. This board, I know, does its best to render fair decisions on disputes that come before it. And it operates under the municipal code and the structure and procedures under municipal code. And that municipal code does not address subcontractor listing laws. So I feel that this process has been a little bit of putting a round peg into a square hole, in that I think there's been a lot of lack of clarity in the process, and that's affected the board's at least decisions in the last go around. In particular, there's no formal process. There's no hearing, there's no order of presentation, there's no appeal set forth in the municipal rules. And it certainly doesn't address or isn't designed for a serious issue like this, because the board's proposed findings as they are right now implicate a serious impact to Stronghold Engineering and its ability to conduct its business, in that its license may be threatened by the purported findings. And the process was not clear, and I felt that the board was holding it against Stronghold for a couple things. One, the timing of the hearing. Initially, the city attorney's office noticed a hearing in October, I think it was 25th. Less than a week before that, the city attorney unilaterally rescheduled that hearing after hours on a Friday by an email notice that doesn't comply with either the contractual notice provisions or any official service of process rules that are in place for service of process, such as something like this. Then another message was sent later that weekend via email, again to my clients, without the 5 days notice required under the listing law, that advanced the hearing by 2 days. It was after my office objected to the city attorney that the city attorney's office rescheduled the hearing. So I don't, again, that's, the process isn't clear, and Stronghold didn't create the process that has led to this hearing the way it went down. In addition,
That's not an issue, Council. The only issue we have before us is the proposed order and the findings in the order. And I suggest you address yourself to that and not to your argument as to the validity of the process or this.
Okay, one of the findings I just addressed.
Andrew, can I interrupt? Can
Yes.
you identify yourself and who you are and who you're representing?
Oh, yes. I'm Andrew Van Arnhem. I appeared at this hearing on November 18th, and I represent Stronghold Engineering Incorporated.
Okay. And we want to limit your comments to 5 minutes. This is not the hearing per se. We've already been through that. We're just finalizing what we've already decided on. And if there's any comments in that regarding the 6-page summary that the City of Monterey has presented.
I will address.
We'll limit you to 5 minutes. That's not the purpose. What you're saying is not the purpose of this hearing.
Okay, so it's my understanding the board did not prepare these findings. This is prepared by the city attorney's office. Is that right?
That's right. And we had 3 binders full of information that took me 2 or 3 days to read.
Okay, then I'll address the findings. The first findings, which I raised about the jurisdiction of the board to preside over this matter from 2-8.01D, that authorizes the board to perform such hearings and appeals that the city council or city manager may from time to time authorize or request. The city attorney didn't put on any evidence that there was a formal authorization from the city council or the city manager to have this board conduct this hearing. And again, as it's a round peg in a square hole, that's an important issue. I'd like to address some of the further hearings here, are the issues.
It's not relevant. Your arguments aren't relevant to what's before this board, what we're trying to tell you.
Thank you, Stephen. I agree.
Okay. Let me address some of the other findings that are listed in this new written submission.
Remember, I gave you 5 minutes.
Yeah. Paragraph 4 says that SEI produced construction records from which the city discovered the use of subcontractors that are giving rise to this hearing. There is no actual evidence of that being true, but what it does confirm again is that this is a litigation strategy by the city attorney's office. It is not consistent with what the case law in this Thompson Pacific case said, that this is a statutory scheme that contemplates an awarding authority monitoring a project during construction. And the public entity has the power to sanction those violations, but the whole purpose is to monitor construction. This is 5 years after the fact. And if this were an ordinary civil proceeding, this would be time barred under the penalty statute and the case law that's been cited by the city attorney.
You're raising the arguments you raised in the hearing. Nothing new.
Okay. As to the finding in paragraph 19 that SEI violated the public contractor code because it substituted a person in place of a subcontractor listed in the original bid, was not demonstrated by any evidence put on by the city attorney's office. In fact, the city attorney's office didn't identify who they claimed was listed for the concrete work, but SEI put on evidence that they listed West Coast Construction, that's who they got a bid from, that's who they got a subcontract from, and that's who the city actually approved to work on the project later on. So there's no evidence that there was a change in intended subcontractor for concrete. The city didn't establish any evidence or put on any evidence that there was a different contractor. In fact, the city admits that there's no, quote, West Coast Concrete. So that's a non-issue. Stronghold did not substitute anybody for that. And frankly, the city accepted FD Thomas by negotiating with FD Thomas to perform extra work on the project, and that evidence is undisputed. Frankly, the delay in bringing this case has prejudiced Stronghold and has resulted in a situation where Mr. Witchery
before in the previous hearing.
Yeah, but let me address these
5 minutes are basically up that I gave you.
All right, let's also remember that the delay has resulted in Mr. Witchery offering the only evidence in this case. He wasn't there during any of the times that these acts were allegedly committed, and the city employee who was there was not brought by the city. The city's construction manager who approved these substitutions was not brought by the city. There's no competent evidence to support these findings. So
we've already been through that. Your time is up. Thank you, Andrew.
I renew my motion.
Okay, is there a second?
Let me just double check with the clerk. Was there any additional public comment?
No, Karen, not at this time.
Okay, go ahead and proceed with the motion, sorry.
Kent, do you have any thoughts or comments?
No, I second the motion.
Okay. Good. All in favor, I guess raise your hand so we can see that.
Oh, we should do a roll call.
Okay, good.
The clerk will call
okay.
it out.
Okay, Board Member Glenzer?
In favor of the motion.
Okay. Board Member Milich?
Yes.
And Chair Hawkins?
Yes.
Okay, the motion passes 3-0.
Okay. Anything else we need to be discussing or considering? That's the main focus of this meeting here.
Probably happy holidays to everyone.
Yeah, true.
Yeah, just if there are any board member comments on regular sort of items that would come before the board that are not on the agenda. Any final comments?
Nothing from me.
No.
Okay. We have one other project pending. Any idea when that will be coming before us, Alicia?
At this point in time, I don't have any set date just yet,
Okay, probably in
but I'll
January.
be in touch when I do find out.
Okay, probably in
Okay.
January at this point, right?
More than likely, yes.
Yeah, I don't expect any more hearings for the remainder of this year. So
Okay,
we will all see each other in 2021, hopefully.
yes. Okay,
Okay.
If that's everything, the meeting is adjourned at 2:18.
okay.
Okay.
Thank you
Bye,
very much.
Thank you so much, everyone.